Hey guys, good morning everybody. So the first thing I'm doing this morning is I'm looking over a friend's sync agreement contract. And so I thought it would be a cool exercise I just finished up to show you guys how I went through it and what I look out for so that you can better audit your own contracts, because you guys are going to get contracts, as you get more and more successful, people are going to pitch you paper. And in the music industry, there's a lot to look out for. The entire industry is ran by contracts. And so all the ways you could get fucked are in these contracts. And there's a lot of ways. This one's a little bit more innocuous than the typical one I see. There's a trusted party, the artist, my artist friend. They like the company, they like the guy behind it. And the paper's not that bad. So I've seen a lot more egregious stuff. And in lieu of having those examples for you guys, I'm going to show you, even in this sort of friendly contract, what I noticed that could end up being a problem. Then I'm going to show you how I fed at one point through the contract audit process. I got a little lazy. I fed the rest of the contract to Claude, which is a lot like ChatGPT, but in my opinion, it's better right now. And asked it to annotate the rest of it. And then I'll show you what I chose from its response. And hopefully what this does is, after watching this, you have a little bit better idea of how you might audit your own contracts, what you're going to look out for, and maybe how to negotiate, thereafter. So let's take a look at it. All right. It is a sync licensing and representation agreement. And so I started reading through it, sort of skimmed through this opening statement. The opening statements rarely contain gotchas. The things you got to look out for are going to be later in the contract than the opening statement. Still good to read. But ultimately, it defines like you're the licensor, we're the company, we, us, our. So it says anywhere through this contract, if we say company, or we say we, or we say us, or we say our, that's this company. If we say licensor or you, that's you, the artist. And so it sets up like, variables for, language they can use. It's effective, on the signing. And it creates a contract between you and the company, whether you're an individual or if you're an authorized representative for an artist, band, group, or corporation, in which case you shall refer to the artist, the band, the group, the corporation, blah, blah, blah. All right, so grant of license works. Licensor hereby engages and grants to company an exclusive or non-exclusive right. So here it's saying it can be one or the other, which means the artist has to define, this is like a multi-purpose contract. This is not the exclusive contract or the non-exclusive contract, it's both. And there's different definitions throughout depending on which the artist selects. So this sets up sort of something you gotta remember as you read through the rest of it is like, okay, depending on what the artist selects, some of this language is gonna mean different things, okay? And throughout the territory is further defined below during the term. So term and territory are common in music industry contracts. You're going to need to know them. Term just means how long they can do X, Y, and Z. There's usually multiple terms. There's usually the initial term. There's option periods where they can extend, and that option might be them. It might be mutual, meaning you both have to agree. In a lot of cases in the music industry, it's just them. They can solely decide whether to sign you up for another year, 2 years, 3 years, whatever. So term is important. There's also collection terms. There's also rights terms. So for instance, if you have an agreement with them, but then you terminate that agreement, well, they might have an extended term during which they can collect payments related to the agreement, things that happened while the term was active. There also might be rights terms where their rights as it pertains to your works extend beyond termination for a period of time, and that'll all be defined. And then territory is like where they can, it's usually worldwide. Sometimes it's throughout the whole universe in case of future space travel. So that's term and territory. So they can access, use, pitch, license, sub-license, distribute. Basically, they can do everything to the extent in which licensor has an interest in such license works for the purpose of locating, soliciting, negotiating opportunities for the license works in all areas of audio broadcast media, including but not limited to all forms of television, including free TV, cable, satellite, direct broadcast, any other type of TV, film, documentary, video games, advertising, commercials, home video, the internet, mobile, and any other form of media now known or hereafter devised. So this is actually not bad, right? Because in a lot of contracts, it's like even sync licensing contracts, you'll see things like, we can use it for whatever the hell we decide. So it's not bad. They can edit, reproduce, and create derivative works in any way we or our licensees may see fit with regards to a particular use. So let's break down that sentence, right? They can edit, reproduce, and create derivative works. Okay, that sounds scary. They can basically sample your stuff and create new stuff, right? But they limit that scope. So edit, reproduce, and create derivative works of any songs you submit to them, the licensed works. Now that's not defined yet. So we're going to want to remember licensed works. What does that mean exactly? Does that mean all my songs? We'll remember that for later. In any way we or our licensees may see fit, however the fuck we want, with regards to a particular use and or project or preference for a variety of contexts. So this limits the scope a little bit, right? It's saying regards to a particular use. And use throughout this contract is kind of means like if we represent your song and someone wants to use it, a licensee, that's a use. So it's not any time we want to do it. It's when it's in connection to a use, which usually means money. And so you're kind of okay with them. And the reason that I broke this down is because in licensing, it's very common. It's very common to need to alter the work that you submitted to them, the song, for many different purposes. So they might want stems even because they're going to need to create stingers. They're going to need to create different types of edits because when people use your work in a TV show or a commercial, they're not just going to put the song in, right? They want to recreate their own version. A lot of sync libraries will prepare the versions that they're likely to need for them. So they'll have just bass and drums. They'll have, EQs for ducking. They will have stingers, which basically means like it's a quick little snippet of the song that can end a scene or begin a scene or end a commercial or begin a commercial. So that's okay, right? Editing and reproducing in the context of licensing, sync licensing, very necessary that they need that. So they can place or embed the licensed works in magazines, websites, their own marketing materials, any and all other media. They need this in order to market the songs to licensees, so that's fine. Use the names and approved likenesses of and biographical material concerning any artists, bands, producers, and or songwriters, as well as track and or album name, and all artwork related to the licensed works in any marketing materials for the sale, promotion, and advertising of the licensed works, which is offered for sale or other use under the terms of this agreement. So basically they're saying, we need your bio and your picture and all other media related to your songs in order to market them. That's fine. Authorize our licensees to perform any one or more of the activities specified above or in an applicable addendum. Basically, we can do this and the people we license to can do this. So that's fine. Now, actually, I kind of just caught something. So let's actually annotate this live together, right? What I caught is that basically they're giving all of these rights we just went over above to the licensees as well. And a potential negative scenario that could occur there is like, okay, yeah, you get that this company wants your likeness and your biographical information to market the song, right? But let's say a scenario where you become just uber famous, right? Now they can use it, which is still okay, but all their licensees can use it. And you don't have control over who their licensees are. So what if you get uber famous, they license out to someone who you don't politically agree with or who is exploiting your name for fame to sell their product or something like that. This basically creates a scenario in which the combination of IV and V basically creates a scenario in which their licensees, people who license your song, could use your name, likeness, and bio to shill their products. I would ask for language in V that limits this ability based on your desires. For instance, you don't want the Nazi party to be able to use your biography and name because they licensed your works. So that's my comment there. All right, notwithstanding the foregoing, licensor shall retain at all times the right to use the licensed works in licensor's own projects for any type of broadcast. That's fine. Customer information. The company may provide you with information relating to customers that license or sublicense the licensed works, subject to the preferences of our customers. You may only use and disclose this information to a third party for your internal record-keeping purposes. You may not disclose any of this information to a third party or use it for any other purpose unless otherwise agreed to. So they're basically saying, like, keep our customer information private. That's fine. Territory for this agreement is the entire world. Why not the entire universe? Licensed works means all works that you submit to the company during the term, whether recorded prior to or during the term, and that you elect for the company to make available pursuant to this agreement. So this limits what licensed works means. Okay, it means you have to submit it to them, and you have to elect for it for them to make it available. So we're not talking about all your rights. We're not talking about all your songs. We're talking about the songs you explicitly send to them and say, represent this. So that's good. It limits the scope of everything. Commission works. If the company commissions you to create a new audio work for the company's client, the company will charge an administration fee of 20% of the total amount paid for the commissioned audio works. Basically what this means is that they find you custom work, which typically has a higher price point. That they get an extra 20% for administrating that custom work. It's okay. Like, there's potential nightmare scenarios herein where in order to bilk you for every extra dime they can, they just treat everything like a commissioned work. So a licensor, they're in a communication with a licensee and they say, we want to license this work. Can we have these modifications for broadcast? So they want all the derivative works of it so that they can use it in an ad. They then go to you and say, this is a commissioned work because they need this custom modification. And then they get an extra 20%. Unlikely to happen, but still, like, it opens the door. If you sign this contract, they totally could do that and it would be legal. So it's not about what they're likely to do. It's about what they could do if you sign this contract. That's what it's always about. And so you want to make sure that you're thinking about that. No guarantees of sales or use. Company makes no guarantees regarding the minimum number of unit sales or uses of the licensed works. In addition, we cannot guarantee that licensees will perform under any agreement they enter into with the company for the sale, distribution, or license use of licensed works, including by paying the royalties they owe us for the distribution of the licensed works. If a licensee refuses to pay us for the use of the licensed works, you agree that you will assume responsibility for collecting any payments that may be due from such non-compliant licensees for any sale, distribution, or licensed use of the licensed works, if such third party fails or refuses to pay such amounts to the company upon the company's request. All right, so what I wrote in regards to this is, this may be the best of a set of bad options. However, ultimately this means that if they find a licensee for your works and they make an agreement with them and they don't pay, they have no obligation whatsoever to go after them. That's kind of all on you. Now, the problem with that is that this basically means that they don't have any liability whatsoever. They don't have any responsibility to guarantee that they're licensing to people who are going to pay you. They could license to anyone. They could license to friggin' like absolute criminals. It doesn't matter. They have no duty of obligation to make sure that you get paid. And that's a problem, but it's also understandable in a way, because what they don't want, their nightmare scenario on their end, is that someone refuses to pay you, and they made every effort to try to get them to pay you, but they just won't do it. And they don't want to be tied up or liable, meaning you could sue them in court for the amount that the licensee owes them and you. They don't want that scenario where you can sue them. And so here's what I said. I said, this is probably just to protect them from liability in the event that they can't collect. Still, if I were your lawyer, and if I were a lawyer to begin with, I would ask that some language be put in here, like, in the event that a licensee does not pay for verified use of a licensed work, company will make a best effort attempt to collect all payments owed for said use. In this context, best effort shall be equivalent to and no less than any efforts employed to collect payments for any other use of any other licensed work for any other licensor or the licensor assigned herein. Basically meaning, okay, you're not permanently liable for non-payment, but you are liable to me to use just as much effort to collect payment as you have ever used. So if you go above and beyond for one client, you have to go at least that heavy for me. I like that language because it still protects them from full liability for the payment, but it does make sure that they're not going to half-ass it. And so that's my modification. Okay, so then this says exclusive or non-exclusive representation. Exclusive representation royalties shall pay licensor. So it's 75%. They're going to pay you 75% if it's exclusive. And then for membership programs, which is like very common nowadays in microsync, where someone signs up, like Epidemic Sound. I sign up for $20 a month. I can use any of the works in the library, as long as I'm subscribed. And any videos I create while I'm subscribed still have that ability to use it after I unsubscribe. Okay, so that's our membership program. You get 60%. And then here's where I kind of got a little thrown off. Exclusive representation administration. Company shall provide exclusive administration. And so basically what this says, I'm not going to read it all out, but basically what it says is if you get your own opportunities for the licensed works, you still have to run them through the company, and I imagine they still take a cut. So essentially this means that they're acting as your salesperson for the licensed works, but they're also acting as your manager. Imagine you submit songs to them and they don't really do shit. The deal pretty much goes cold, nothing's happening, life goes on, you find your own opportunities for licensing. Well, those opportunities now have to be run through them. This person who the deal soured with and who hasn't been doing shit for you, now you have to send the person you formed a relationship with to them to negotiate, which kind of really sucks. You can imagine how incredibly stale that could be in the worst case scenario. So this only applies if you decide to go exclusive, which is a 75% cut of what they found you. Non-exclusive is a 60% cut. And then I just wanted to outline that. Now, you might think like, isn't that what exclusivity means? And it's like, well, no. It could just mean that they're the only person you can sign up with for sync representation, but you can also represent yourself. So that's exclusive in terms of I'm signing up with a third party to be my sync person, but I can find my own opportunities if I want to. That might be a middle ground between non-exclusive and exclusive here. All right, so let's continue on. So I'm just going to skip forward and find you some of the other things that I identified. Everything here is just fine. It's a lot of boilerplate. It's just definitions, what does secured use mean? What does net receipts mean? What does membership mean? What does custom license mean? What does administration mean? So it defines the scope of those terms in the contract. And then what does upgrades mean? Let's go to representations and warranties. So licensor shall choose whether company will represent licensor in an exclusive or non-exclusive capacity in relation to the license works. Yep. Each party represents and warrants that they're authorized to enter into this agreement, so they don't have any previous agreements with other people that limits them or makes it illegal for them to enter into this, contract. They're not going to act in any manner that conflicts or interferes with any existing commitment or obligation of the other party. That's fine. Performance obligations hereunder in full compliance with any. Yeah, they're going to follow the law. Great. Now the licensor, you guarantee to them that you have the full right and title and interest and copyright to the licensed work. So if you submit something to them, you better have all the rights cleared. Like it better be yours. And this includes like language for, what if we're talking to a band and not like a single solo artist? The licensed works are original. Neither the licensed works nor any of their contents or any other materials, blah, 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 blah. Jesus, this is long. None of this shit you're submitting infringes on any copyrights. That's basically what it says. Licensors comply with all credit obligations, whether they arise contractually or otherwise. Any requirements and restrictions, basically saying like, no casual or inadvertent failure by company to give credit to licensor or any other person shall constitute a breach of this agreement. Basically saying like, we don't have to credit you, which is fine. Like in a sync context, that's fine. As of the signed agreement date, there are no current or pending legal claims against you or the company, but this specifically relates to you. And I imagine like companies like this get sued all the time, so it's not really feasible to have it be applied to them. If any portion of the license works are now in the future administered in any territories by any performance rights society or any other collection society, you will be responsible for ensuring that such collection societies are notified of this agreement. So you got to tell ASCAP, you got to tell BMI what you're doing. All right, term. The term of this agreement shall be for 12 months from the effective date, the initial period. The term shall automatically renew for additional 1-year periods, each a renewal period, unless either party decides to terminate this agreement by providing the other party with written notice. Termination notice, at least 30 days before the end of the initial period or renewal period as applicable. Basically, you have to tell them that you want to terminate before the extension, or it extends for a year. Now, here's where I gave everything to Claude, and let me show you what that looks like. So here's Claude AI, and I said, I'm auditing a licensing contract for my friend. They will likely be signing as non-exclusive. I've read through about half of it. I added notes, but I want you to read through the rest, look out for any gotchas or hidden language. You can basically use this as a prompt template. Now, for context, I typically audit these things looking for worst case scenarios that the language doesn't really account for. For example, I found one in this clause, and I just gave it an example of what I already found. So here's the clause, and then here's my comments about it. And now here's the rest of the contract, and I pasted it in. And Claude read through it and gave me this artifact, which is like the specific section, subsection, what the section says, and then why they're concerned, and then what the suggestion would be. And it did this for the whole rest of the contract. I could have fed it the whole contract, and I probably would have caught all this shit, which is really cool. So I use AI every day now. I'm deep into it, and it's really good for pretty much everything. But I used it for this, and here's what it recommended. So I'm going to go through what I chose from what it recommended, because I didn't choose everything. It said, where is it? It has up to 30 business days to remove works after a termination notice. This could be a long period during which the artist's works are still being licensed against their wishes. Negotiate for a shorter removal period, e.g. 10 business days. All right, so Claude here is saying, basically, if they get a termination notice, they have to remove your works from their website, remove it from their catalog, make sure it's not pitched to anybody. In the contract, they have 30 days to do it. Claude said, like, maybe do 10 days. That's not really feasible, and it's not really a huge problem that they have 30 days. So I didn't go with that. So just an example of like what I didn't go with. But I did go with this one. Contract automatically renews for additional 1-year periods unless terminated with 30 days notice. This could lead to unintended long-term commitments if the artist forgets to terminate. Request a reminder notification from the company before the auto renewal date. And I like that. I like that idea of like, don't just auto renew. Tell me you're gonna auto renew. Send me a notification. I like that. That protects you. And then this other one. Any licenses that during the initial period or any renewal period shall have been issued by a licensee or a customer of a licensee for the use of any of the licensed works as permitted in this agreement shall continue and remain in full force and effect, it being agreed that the term of the licenses shall be separate and apart from the term and will accordingly survive termination of this agreement. So all the licenses remain in effect after termination. So this could lead to ongoing use of the artist's work without their direct control. I would request a clause that limits the duration of post-termination licenses. Now, let me actually modify this live with you guys. This should apply only to licenses that are auto-renewed and connected to new payment schemes. So, auto-renewed or renewed in some form and connected to new payment scheme. So basically what this means is if they license your track to someone and the license auto-renews, the license agreement auto-renews, at some point it should sort of revert back to you. If the license is forever and none of it has to be renewed or agreed to again, then it makes sense that they should continue to collect and the license should remain in effect. Yeah, it's basically saying like, look, yes, like you're no longer my licensor, right? You don't license on behalf of me. So if you create some complex contract with someone you're licensing my track to, where like, hey, if we don't hit you up, this auto renews. So like we're defining an initial term you want to license it for, you will definitely pay us and use it during that term. But if you want to continue using it, it auto renews after initial term of like 3 years, right? So after 3 years, even if the artist is terminated with us, this license remains in effect by renewal. Basically saying like they could create contracts that mean that they continue to profit off of your licensed works long after you've terminated them. I don't like that being forever. Maybe, you know, if you're negotiating this contract, you might think like, well, if they got me the gig, then I want them to have, you know, the license for, you know, forever if necessary, and I want them to profit from it if necessary, but I don't like it. Okay, liability after withdrawal of rights. After the takedown notice, okay, if the agreement has been terminated, so if we cut this agreement, the company's not responsible for any delays of our licensees in removing the licensed works from any websites or services owned or operated by such licensees. Basically saying like, if your work ends up on websites like Epidemic Sound, or even the language of this isn't really very clear. It could mean if your work is on a website because that's what they licensed it for and it's playing live when someone visits the website. It could be in connection with a license. The language doesn't clarify. After we give them a takedown notice, you're responsible for enforcing your rights. So if you terminate with us, we'll send a takedown notice. But if they don't take it down, you got to chase that down in court. This is a lot like that previous example where it's the best of a bad set of options, and this is just to protect them from being liable. It could be a nightmare scenario where someone just outright refuses to take it down. And you've terminated the agreement with them. And they don't want to be like liable legally to continue like expending resources to try to get this person to take it down if they just simply refuse. So they're limiting their liability here. And I said, I think we understand that if they were fully liable, that may be an unfair burden on them for the behavior of the licensees. However, I'd still probably ask for best efforts, right? If you went above and beyond for any other artist or for any other work to get it taken down, you go above and beyond for me. You don't give me less effort than you gave someone else. Sorry about that. All right, so additional provisions, entire agreement, blah, 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 governing law. This is all perfectly fine. Assignment. During the term and collection period, company may freely assign this agreement. Incredibly common. Companies get bought and sold all the time in the music industry. They probably end up becoming a part of some major publisher or one of the 3 major record labels, and you know, it's very common. I said it's incredibly common. It's worth noting how this modifies any other comments I've made. Maybe you trust this guy you talk to and this company, so you let all the other things I pointed out slide because you trust them to do the right thing. That's fine, but do you trust everyone that they could assign the agreement to? No, you don't know all those people. So assignment modifies it, right? It's like, yeah, they're securing their liability in worst case scenarios and don't worry about it because you trust them, but then they assign it to someone. And that person now could be a complete villain, and all the worst case scenarios I outlined could be entirely likely all of a sudden. So I just left a note here to say, like, given this, consider everything else I've said. If you thought you would let all these other things slide because you trust this person, well, do you trust everybody? So that's what I put there. And that's it. That's the rest of the contract. So hopefully this shows you how I look through contracts. I read every clause. In this case, I gave Claude the contract, and I might do some follow-up. Like if I weren't reading the whole contract, I might do some follow-ups with Claude to say, like, is there anything else you can spot besides what you listed that might be a problem or I might want to examine? I wouldn't just like single shot prompt, take all the things and be like, all right, you're good. Everything else is fine. But in previous instances, I've read mile-long contracts, clause by clause, looking for the dirt, and I've found it. I've found it many, many times. So hopefully this opens the door for you to audit your own contracts. You do not need, first of all, I want to be clear that an entertainment lawyer, most entertainment lawyers, will not do what I just did. You would think like they're lawyers, they're entertainment lawyers, of course they would. They look over so much goddamn boilerplate that one, they've become numb to reading it, so they're not really looking as hard as I am. Two, they have become numb to fuckery. They've become numb to just like worst case scenarios falling on the artist all the time. So they will read over something that's like egregious and just be like, looks good, looks standard, you know, go ahead. So I prefer to read the contract. Even so, I had a friend, a group that was signing with a management firm. Management firm was doing like a co-deal with a production guy, and the production guy was a fucking snake. The paper that they gave them, I negotiated for better terms. The paper that he gave them, I was like, you should never talk to this guy again. You know what this says? This is insane. Like, I won't even get into it, but it is insane what, if they signed it, it would have meant for them, and how he represented none of that when he came to Orlando, hung out with them, got them drinks, got them dinner, told them everything was all good, and then sent them this paper. It was fucking insane. And so I read through every clause looking for all that stuff and making sure I understand it before they can sign it. And I do not trust entertainment attorneys. Another reason not to trust entertainment lawyers, like have one, sure, is that entertainment lawyers, you got to think of the music industry as this hegemony where there's 3 firms that really matter in the music industry, the 3 major record labels. And then there are some major publishers that matter. Okay, major sync licensing entities that matter. But the firms that matter, 2 hands I can count them on, okay? And the problem with that is that any entertainment lawyer has to deal with them every day, has to deal with them, has to negotiate better terms for their clients with them, has to see them in court, okay? So they want to be friendly with these firms, okay? It means they're going to get more clients because the firm will recommend that they be the entertainment lawyer for the client, and that happens. It should be, it is illegal. It's illegal for your counterparty to choose your lawyer for you, but they do it all the time in the music industry. So entertainment lawyers have all the reason in the world to play very nice, put on kid gloves. And what that does effectively is, imagine you have a space of possible legal maneuvers that I could pull as an entertainment lawyer to get my client the fairest representation, to get them the best deal. There's a wide range, let's call it a space. It has dimensions. I could move in the friendly direction. I could move in the more aggressive direction. I could move in the artist protection direction. It's a space of possibilities. What the fact that there's only 10, less than 10 major firms does is it cuts that space of possibilities in half or even worse. Meaning an entertainment lawyer could do all these other things. They won't do them for you. They will never do them. And they won't read over your contract with that critical eye because they need to play nice with these firms. So have an entertainment lawyer by all means, but read your own paper. And hopefully I've shown you that it's not that crazy to read your own paper, understand it, and ask for fairer terms. And if someone ever tells you, oh, don't worry, this is standard, be like, okay, cool. Well, I don't give a shit that it's standard. I'm talking about my future here. Okay, so I don't care that you regularly screw over all these other people or that they weren't smart enough to bring it up. I have a nightmare scenario here that I would like accounted for, and all it takes is a little language change. And if it's true that you're saying that you're not trying to do the worst case scenario, then you should have no problem adding this language, which just limits that scenario. Key example is the clause where I said the best efforts thing, right? If it's true that they're not trying to screw you over, they're just trying to limit their own liability, well, then this best efforts thing should be no problem, okay? So never accept, oh, this is standard, don't worry about it. That's absolute bullshit, and that's how they get away with murder. So I hope this helps. I hope it's insanely useful to you guys. I would have made a more prepared video, effects and graphics and shit, but it's early in the morning and I was just going over it. I thought this would be quick and cool. So I hope that helps, guys, and I will see you out there.